thing I wanted to go over with you, and it has to do with the marriages we talked about yesterday, with the blueprint of a marriage. And this was derived from a conversation, an enlightening conversation with the Marriage License Bureau of Arizona. Okay? About 20 years ago, my former wife filed for divorce. We had 7 children, 5 daughters and 2 sons. Our youngest at the time, our second son, was 5 years old. At the time I prepared a counterclaim to the petition for dissolution her attorney filed in domestic relations court. I met one afternoon with the head of the Maricopa County Superior Court Marriage License Bureau in downtown Phoenix. The Marriage License Bureau was headed by a young woman of about the age of 25. I asked her to explain to me the general and statutory implications of the marriage license. She was very cooperative and called in an assistant, a tall black man who at the time was working on an operations manual for internal departmental use. She deferred for most technical explanations to her assistant. He walked through the technicalities of the marriage license as it operates in Arizona. He mentioned that marriage licensing is pretty much the same in the other states, but there are a few slight differences here and there. One significant difference he mentioned was that Arizona was one of 8 western states that are community property states. The other states are common law states, including Utah, with the exception of Louisiana, which is a Napoleonic Code state. Yeah, they're under the Napoleonic Code. Louisiana, when I go down there and work on cases, it's a whole different thing.
I mean, I knew they were kind of their own country, but...
Pretty much. Pretty much.
I didn't realize they were France.
Yeah. He then explained some of the technicalities of the marriage license. He said, first of all, the marriage license is a secular contract between the parties and the state. The state is the principal party in the contract. The husband and wife are secondary or inferior parties. The secular contract is a 3-way contract between the state as principal and the husband and wife as the other 2 legs of the contract, just like the blueprint yesterday. He said in the traditional sense, a marriage is a covenant between the husband and wife and God. But in a secular contract with the state, reference to God is a dotted line and not officially considered included in the secular contract at all. Exactly like the blueprint of a marriage on the United States Patent and Trademark Office. Okay? He said, if the husband and wife wish to include God as a party in their marriage, that is a dotted line, they will have to add in their own minds the state's marriage license is strictly secular. He said further that what he meant by the relationship to God being a dotted line meant that the state regards any mention of God as irrelevant, even meaningless. In his description of the marriage license contract, the related one other dotted line. He said in a traditional religious context, marriage was a covenant between the husband and wife, and God with husband and wife joined as one. This is accomplished with a recording in a family Bible with 3 witnesses. Where do you think I came up with this stuff, right? I don't just invent things, okay? I research, I find it, I figure it out, and then I present it. This is not the case in the secular realm of the state's marriage license contract. The state is the principal or dominant party. The husband and wife are merely contractually joined as business partners, not in any religious union. Okay? They may even be considered, he said, connected to each other just by a dotted line. The picture he was trying to paint was that of a triangle with the state at the top and a solid line extending from the apex. The state down the left. I didn't even find on the United States Patent and Trademark Office website the patent of a marriage until long after this. years after this. He was describing it to a T, and then I found it and I go, oh my gosh, here it is. It's patented. It's a patented process. Just drives me crazy. Okay. The dotted line merely showing that they consider themselves to have entered into a religious union of some sort is irrelevant to the state. Marriage license secular contract diagram. State is primary in the party. The husband-wife is secondary in the party. He further mentions that this religious overtone is recognized by the state by requiring that the marriage must be solemnized either by a state official or by a minister of religion that has been deputized by the state. That's why the preacher has to get licensed by the state to perform a marriage. He's deputized by the state, which makes him an agent, right? Well, go ask your bishop if you can get married in the temple without a state license. Tell me what he says.
No, the answer is no.
I know that. Okay, that's because they've commercialized. Goes back to the attorney running the church. Okay? So the minister of religion that has been deputized by the state to perform the marriage ceremony and make a return of the signed and executed marriage license back to the state. So it's his responsibility to return it signed by him as agent. Again, he emphasized that marriage is a strictly secular relationship so far as the state is concerned, and because it is looked upon as a privileged business enterprise. So you just go into business with your wife when you marry her with the state, right? Yeah. Various tax advantages and other political privileges have become attached to the marriage license contract that have nothing at all to do with the marriage as a religious covenant or a bond between God and a man or a woman. By way of reference, if you would like to read a legal treatise on marriage, one of the best is a book called Principles of Community Property by William D. Funiak. At the outset, he explains the community property law descends from the Roman civil law through the Spanish codes dating as far back as 600 AD, written by the Spanish jurisconsulates. In the civil law, the marriage is considered to be a for-profit venture or a profit-making venture, even though it may never actually produce a profit in operation. And as the wife goes out to the local market to purchase foodstuffs and other supplies for the marriage household, she is replenishing the stocks of the business and or its inventory. To restate, in the civil law, the marriage is considered to be a business venture. Moreover, as children come into the marriage household, the business venture is considered to have borne fruit. Now back to the explanation by the Maricopa County Superior Court Marriage Bureau's administrative assistants. He went on to explain that every contract must have consideration. The state offers consideration in the form of the actual license itself, the piece of paper, the certificate of marriage. The other part of the consideration by the state is the privilege to be regulated by your statutes.
That's such a privilege.
Regulated by your statute.
By their statutes, yeah.
Just through being married.
Isn't that a privilege?
Yeah.
Once you change your status, you can rescind your contracts. I actually have a document that I used for myself to annul the state of Nevada, because that's where I got married. So I took the state out of the contract. He added that this privilege to be regulated by statute includes all related statutes and all court cases as they are ruled on by the courts, and all statutes and regulations into the future in the years following the commencement of the marriage. He said, in a way, the marriage license contract is dynamic or flexible. What did we talk about the word dynamic means yesterday in the law? To keep moving, just keep moving. So it's flexible, it keeps moving. Ever-changing contract as time goes along, even though the husband and wife doesn't realize that. My thought on this is that it can really be considered a true contract as one becomes aware of the failure by the state to make full disclosure of the terms and conditions. But remember, in court, presumption and assumptions, so must be repudiated in all aspects or you give over jurisdiction. A contract must be entered into knowingly, intelligently, intentionally, and with full informed consent. Otherwise, technically, there is no contract. But you go try telling the court that when you're a citizen, right? They could care less. The marriage license contract with the state is a contract of adhesion, a contract between two disparate, unequal parties. Again, a flawed contract. Such a contract with the state is said to be a specific performance contract as to the privileges, duties, and responsibilities that are attached. Consideration on the part of the husband and wife is the fee paid for the application and the implied agreement to be subject to the state statutes, rules, and regulations in all court cases ruled on regulated to marriage law, family law, children, and property. So the minute you fill out the application and pay the fee, you just bound yourself to the state statutes, rules, regulations, all court cases relating to marriage law, family law, children, and property.
Which essentially took all your rights away.
Yeah. Yeah, they took away your unalienable rights and gave you privileges and bound you to their contract just by going down and paying the fee and filling out the application and getting married. When you could have took the family Bible, you could buy at Deseret Industries for $40, recorded on the first few pages, take a scanned copy of it, write a little affidavit, and go record it on the county recorder's office, and you're just as legally married. But now, not with the state, but with you, your wife, and God. That's the proper way to get married. That's the way we got married for hundreds of years before this whole system of fraud came into effect.
You're stuck.
Now,
Let's hope that you have to get divorced first.
you know, you really need to annul the state for the fraud that they committed, for the cause of fraud and swindle, no full and honest disclosure, right?
Yeah.
And then get married the right way in the Bible, go record it.
Okay.
Yeah, if you go back in like Family Search or Ancestry.com or one of the other genealogy programs, and you go back and you search records like 1600s, 1700s, you'll see everybody recorded it with the church in the family, in the Bibles of the church records, and then it was recorded. And you can pull up those recordings even today from 1620.
So how would you do like the ceremony or whatever? Do you have somebody marry you, or can you just exchange vows, or like how does it work?
You can do it however you want to do it. It's between you and your husband and God. Make the decision. Get on your knees and pray about it. There's no set way.
Just people fall into a pattern.
You record the event in the Bible. You get some witnesses who attended, who were there. They could be family members, and then just go record it. But do it in a little one-page affidavit, just agreeing on the event in the affidavit. Go get it notarized, attach it to the photo scan picture of the Bible where you recorded it. The Bible is the law. It's Public Law 97-280, passed by Congress, that the Bible, the Word of God, this country was founded on Christian principles, and it is law. Congress declared the Bible, passed in 1982. Took them that long. In fact, 1983 was declared the year of the Bible. Okay? Have had a presidential declaration that 1983 was the year of the Bible.